Hi and Assalamualaikum. My name is Nur Aisha Amira binti Abdul Rahman. So today I will be presenting a case involving an individual named Ho Chung Man who was arrested and detained under the Security Offences Special Measures Act 2012 and also known as SOSMA. This case raised an important constitutional and procedural issues regarding the legality of the detention and the protection of their personal liberty. After his arrest, Ho Chung Man filed a habeas corpus application to challenge the legality of his detention. He argued that his detention was unlawful for several reasons. Firstly, the police failed to notify his next of kin of his arrest, which is a mandatory requirement under Section 5, Subsection 1, Clause A of SOSMA. Secondly, he was denied access to legal counsel beyond the permitted 48-hour delay, which was not properly authorized, violating Section 5, Subsection 1, Clause B of SOSMA. There was also a confusion about the actual date of his arrest, affecting the legal detention period under Section 4, Subsection 5 of SOSMA. He claimed that these procedural breaches violated his constitutional right under Article 5, Subsection 3 of Federal Constitution, which guarantees the right to be informed of the arrest and to consult a lawyer without any unreasonable delay. However, before the court could make a decision on his habeas corpus application, Ho was formally charged under the Anti-Trafficking in Persons and Anti-Smuggling of Migrants Act 2007. Following the charge, he was remanded by the Session Court under a valid remand order. In its decision, the court acknowledged that there were indeed a procedural breaches during the early stages of Ho's detention under SOSMA. However, the court also had that once Ho had been formally charged and remanded, his detention no longer fell under the scope of SOSMA. Instead, it was now governed by the ordinary criminal process, specifically through a valid remand order issued by the court. The court said that the habeas corpus requests are no longer matter because Ho had already been officially charged and remanded. The judge said that instead of asking to be freed through habeas corpus, Ho should now apply for bail under Section 13 of SOSMA. Now I will pass to the next presenter.
Hi, Assalamualaikum. My name is Nurada Emeline binti Effendi. Today I'll be talking about latest case in constitutional law, which is Sudhanshu Chandra against Ketua Pengarah Immigration Malaysia and others. Basically, this case was talking about an employee, a Bangladeshi employee who was working in RCM Cemerlang M. Sudan Berhad. He was arrested by immigration for illegally working in a coffee shop while on leave, which violates an offence under Regulation 39 Clause B of Immigration Regulation 1963. This causing him a detention for 14 days under Section 51 Clause 5 Clause B, and he was offered a compound fine of 300 ringgit. However, this was paid by his employer. Basically, what are the constitutional issues that was involved in this case? The issue in this case revolved around Article 5 Clause 4 of the Federal Constitution, which guarantees protection, personal liberty, which concerning a lawful detention of non-citizens. The next thing is, what are the federal court's decision against this case? There are a few highlighted points on this case. The first one is detention under Section 35, which the appellant was believed to have breached immigration laws and in line with Article 5 Clause 4, where he was produced before the magistrate for 14 days. The second point was detention under Section 34. After the deportation order, it allows detention and while arranging the deportation, even though the person was not convicted under major immigration offences. The third point is deportation order cited Section 56 Clause 2, which was incorrect and made the order invalid, even though the authorities acted in good faith. So, the federal court allowed the appeal made by the Sudhanshu Chandra, and the writ of habeas corpus was granted. Thus, the appellant's release was confirmed due to the invalid deportation order. However, what are the legal principles that cause the federal courts to make such a decision? the federal court decided that Sudhanshu Chandra's detention was mostly lawful, which is in line with Article 5 Clause 4. However, the court rejected the argument from the appellant that notice had to be sent by post since it was personally served to the appellant. Based on precedent in Hua Kim Wee against Ketua Pengarah Immigration, there is no legal duty for the minister to provide reason for the cancellation of a pass. And a significant principle from the judgment is that technical error in legal documents can invalidate such orders even if done in good faith. That's it from me. Thank you.
Next, in the case of Alauddin against Ketua Pengarah Immigration, provides crucial insights into the legality of immigration detention and removal in Malaysia, particularly concerning non-citizens. Let's look at the facts. Alauddin and 6 others were arrested by the immigration officers. He was found to be working without a valid permit. His work permit had expired in January 2018 and a special pass in March 2018. Interestingly, he had registered with the government's rehiring program back in 2017, but his application was still pending. Despite this, he was detained and a removal order was issued against him under the Immigration Act. Alauddin then challenged his detention by applying for a writ of habeas corpus, arguing that his detention was unlawful because he had registered for the rehiring program. So the core of this case revolved around Article 5 Clause 4 of the Federal Constitution, which safeguards an individual's right to be brought before a magistrate and questions the legality of his detention and removal. It examines how these fundamental rights apply to non-citizens under immigration law. The High Court dismissed Alauddin's application, affirming that both his detention and the removal order were lawful and valid. The court clarified a key point, which while Alauddin had registered for the rehiring scheme, this did not change his status as an illegal immigrant once his previous permits expired. An expired permit means his presence in Malaysia became unlawful. So the court found that the removal order was correctly issued because his permit had indeed expired, making his presence unlawful. Importantly, the court confirmed that the authorities had fully complied with the requirements of Article 5 Clause 4 of the Federal Constitution. Alauddin was brought before a magistrate within the legally stipulated 14-day period, a rule that is strictly applied to non-citizens arrested under immigration laws. So this judgment underscores the strict compliance expected with immigration procedures for non-citizens in Malaysia. It emphasized that even participation in a rehiring program does not automatically grant legal status or override the unlawfulness of an expired permit, and it clarifies the application of constitutional safeguards in the context of immigration detention.
Hello, so my name is Nurfarimita Roslan and my matric number is 077800. So I will be talking about a case named Murali Raj and Lelaki Balas Subramaniam against Timbalan Menteri Dalam Negeri and others. So basically, the detainee Murali Raj was arrested on the 30th of April 2017 under Section 3 Clause 1 of the Dangerous Drug Act, Special Preventive Measure. So he was suspected of being involved in drug trafficking activities. Because the investigation couldn't be completed within 14 days, the officers applied to the Deputy Minister to extend the time. Then, on 15th June 2017, a detention order was issued under Section 6 Clause 1 and Murali Raj was detained 2 years at Pusat Pemulihan Akhlak in Kelantan. Now, he filed a writ of habeas corpus challenging the legality of his detention. So, he brought up a few issues, including he wasn't given a Tamil interpreter when his statement was recorded. Second, he didn't get an access to a lawyer during his arrest and detention before the detention order. And third, Form 2, which was noticed for the advisory board hearing, wasn't actually translated into Tamil. So he claimed that all of this went against Article 5 Clause 3 of the Federal Constitution, which is the right to consult a lawyer when arrested. So the court has to look at two main constitutional issues. The first one was his right actually under Article 5 Clause 3 violated, and second was their compliance with procedural rights, especially since this detention was done under a special law made under Article 149. So at the end of the day, the court dismissed his habeas corpus application. They found that first, he did have a Tamil interpreter during his statement. Second, even though he wasn't given access to a lawyer immediately, the court said that Article 5 Clause 3 it actually isn't absolute in cases like this, because law falls under Security Article 159, which allows certain rights to be restricted for national security. And yes, Form 2 wasn't in Tamil, but since he understood Bahasa Malaysia and had a lawyer during the advisory board process, it didn't really prejudice him. The legal takeaway here is that law made under Article 149, like the DDA, can override some fundamental liberties, including the right to legal representation at point of arrest if national security is at stake. So the court also said that advisory board rules do give some chance for legal representation, which was followed in this case. So overall, court found no procedural errors and detention was upheld. That's all. Thank you.
So I will continue with my case, which is the case of Kong Tung Kian and others against Inspector Muhammad Azamuddin bin Mukhlas and others, which is a new case in 2035. And this case focus on Article 5, Clause 4. So let me tell you a bit about this case. Is that the applicant were arrested on 12 June and being produced before a magistrate within the 24 hours on the 13th June, but the application was refused. Later, even though it was already been refused, he still been detained until 7 PM on the same day and then re-arrest and produced again before a magistrate on the 14th June. So the second remaining application also has been dismissed, and the court ordered that he must be released not late than 12 noon. However, they detained him until 6 PM on the 14th June due to the administrative delay, which is that there is a problem with the police bail paperwork. So the applicant argued that their detention is beyond the magistrate refusal of remand. So it is considered unlawful under Article 5, Clause 4 of the Federal Constitution and Section 38(3) of the Criminal Procedure Code. So the issue that can be involved in this case is that whether the 8-hour delay has breached the Article 5, Clause 4 of the Federal Constitution, which prohibits detention beyond 24 hours without a magistrate approval. So for the legal principle, there are three legal principles in this case, which is the first one is the habeas corpus, unlawful detention, and also the remedy. For habeas corpus, even though the applicant were released by the time of the hearing, the legality of the detention remain a live issue here. The court must assess the detention legality from the date of the filing application. Next is the unlawful detention. Unlawful detention is that detention beyond the magistrate refusal of remand 8 hours was considered as a unlawful prima facie under Article 5, Clause 4 of the Federal Constitution and Section 28, Subsection 3 of the CPC, which says there is no judicial authority justifying for the delay. And lastly, for the remedy, is that the High Court declined to grant habeas corpus since the applicant were already free at the time. So lastly, for the enlargement, as I stated, the High Court is rejected or refused for the habeas corpus application because the applicant were no longer being detained. However, it had been affirmed that the 8-hour post-refusal detention was considered as a potential unlawful under Article 5, Clause 4. So the applicant can request to file a civil suit for damage as a dispute to be put in the trial evidence. So the court stated that the legality of the detention is assessed at the filing date, even if the detainee is later have been free. So that's all from me. I'll pass to the next presenter.
So I'm going to be presenting a case named Shahir bin Rosli against Deputy Minister for Home Affairs Malaysia and others. This case is about when Shahir bin Rosli was detained under the Dangerous Drugs Special Representative Measures Act. This was when Inspector Tan, authorities in charge at that time, served a detention order to the applicant Shahir along with the grounds, statement of facts and 3 copies of Form 1. In the said document, Shahir was informed of his rights, which includes the right to legal representation and to make representations to the advisory board. Although the document suggested Shahir initially wanted a legal representation, Shahir was not represented by one during the representation hearing, which is the advisory board hearing. So he filed for habeas corpus, saying that the detention was unlawful and it did not follow proper procedures under Article 5 sub 3 of the Federal Constitution. So the issue in this case is whether the authorities violate Article 5 sub 3 of the Federal Constitution by not providing Shahir legal counsel during the advisory board hearing.
And the decision of the High Court is that the court found no violation of Article 5 sub 3. Even though Shahid had previously stated that he wanted a legal representation, he turned down the advisory board's request for legal representation twice during the hearing. So according to the court, he voluntarily gave up his right under Article 5 sub 3 after being fully informed of them. So the detention order was upheld and there was no procedural non-compliance. Legal principles in this case is that Shahid himself voluntarily waives his right to legal representation after being fully informed of it, and this does not mean that it amounts to a breach of Article 5 sub 3 of the Federal Constitution. That's all from me. Thank you.